Hello and welcome. Welcome to the Red Wagon Estate Planning and Elder Law Show, hosted by me, yours truly, Jeffrey Belomo, where we discuss all things estate planning and elder law. And well, hey, anything else we want to talk about. And today's podcast is going to fall squarely in the estate planning and elder law arena, as we are going to be discussing celebrity estate plans. Some are successes, some are fails, and we're going to talk about what we can learn from these celebrities who passed, some with good estate plans and some without. So this is going to be a lot of fun. I have been wanting to do this podcast for a long time, so I'm really looking forward to it. Just as a reminder, please do not take what you take from this show, or any other show for that matter, to constitute legal advice. If you are looking for legal advice to create a plan or to get advice on something specific to you, please contact an attorney in your state that is licensed in the state that you reside in and that practices in the area that you are looking for advice in. Then and only then can you retain an attorney and get legal advice pertaining to your specific situation. This show, and any other show for that matter, is for informational, educational, and entertainment purposes only. If you would like education in estate planning or elder law, please give us a call at 717-845-5390 or check us out on the web at www.belomoassociates.com. We offer free educational workshops in estate planning where we will discuss everything from powers of attorney, medical powers of attorney, living wills, last will and testaments, and trusts, revocable, irrevocable, asset protection, pure grantor, you name it, we will discuss it through the use of a radio flyer Red Wagon, when we will explain what it means to have one and how you can get your assets protected, or how to avoid probate by using the Red Wagon and getting your boxes placed in the wagon. If you're looking for advice in a crisis situation, maybe somebody is entering a nursing home or will be entering a nursing home in a very short period of time, we also offer free educational workshops in the Medicaid crisis context, as well as special needs planning. If you have a loved one with a disability and they are receiving public benefits or may be receiving them in the future, and you want to make sure that the inheritance that they receive is protected, you can do that through the use of a special needs trust. In our special needs trust workshop, we will discuss everything from first-party trusts to third-party trusts to able accounts to pooled trusts, along many more items in the special needs workshop. We also have a life care planning workshop. Our social worker does a wonderful job in the workshop explaining what life care planning is and why it is important to have a client care advocate on your side to help you navigate the futures and have you navigate what is going to occur as you age, how to stay in place in your home and live where you want to live, and to the extent that you need to go somewhere, when that should occur, and also how to do it in the best transition possible. In the unfortunate event of a loss of a loved one, we also offer administration workshops where we talk about trust administration and probate administration, and that will teach you what process you must go through if you lose a loved one and you are named as an executor or a trustee of a trust, and what liability you may have if you don't do it properly. So if you're looking for education in any of those areas, at Belomo and Associates, we offer them on a very regular basis, and you can get that information by calling the office at 717-845-5390 or on the web at www.belomoassociates.com. All right. Now, today on this podcast, we are going to be talking about celebrity estate plans. And I have several celebrities that I'm going to talk about. Some planned well, and some didn't plan so well. So I'll talk about it, and then we'll talk a little bit about what lessons we can learn from the celebrities and what we should take from it. Now, I know it is really easy to talk about celebrities and say to yourself, well, that doesn't apply to me because I don't have that kind of wealth or I don't have that kind of money. And that is the first thing that I want to dismiss right out of the gate. I'm not using celebrities as an example because I'm equating the amount of wealth that we have with what they have. But what I'm using them for is to show that no matter how much money you have, without a proper plan, horrific things can happen to your family. And some of these examples are going to show you that, you wouldn't have had to have hardly any money to have a disaster occur. It just so happens that we know who these people are, but it has nothing to do with the money. Remember the stories that I tell on this show, everybody over the age of 18 needs a financial power of attorney in place. Who is going to make those financial decisions for you? If you can't make it for yourself, who's going to make those medical decisions for you? That's what estate planning is. Estate planning is having documents in place so that we are not relying on the government and we're not allowing our family members to fight and to argue. Just so happens some of these examples, they have a lot of wealth, but you will see that the disputes would have occurred whether there was a lot of wealth or not. So please use these as a lesson in, look, I've got to get this in place. And the complexities might certainly be simpler, but the necessity does not get less or is not any less for us without a ton of money. Please refer to some of the other shows where we've talked about, very little money. You need people to make decisions for your healthcare decisions, your end of life decisions, who's going to pay your bills. That has nothing to do with millions of dollars. And those are some of the lessons that we're going to learn. So first, I'm going to talk about Elvis Presley. Elvis Presley was my mother's favorite. She loved Elvis. And so as I was doing some research on this, I thought, you know what? We're going to start and learn. I didn't know anything about what the estate plan was. I think most of us probably know who Elvis Presley is and his daughter, Lisa Marie. So we're going to talk a little bit about Elvis first and then Lisa Marie and some lessons we learned there. So for Elvis, he did establish a trust for Lisa Marie, who is his daughter. And that part is great, right? Now, in the estate planning that Elvis created, the trust for Lisa Marie dissolved at age 25. So I'm going to give kudos. The trust was the right move, right? A trust is a way, when a person passes away, to make sure that the money goes to the child or to the beneficiary, but in a way that it is protected so that only that person can receive the money. Now, I think where we made a mistake in this case is that we dissolved the trust at age 25. And you will know from our workshops and all of the podcasts and shows that we have done that even when we have a trust, we give full control to the beneficiary at a certain age. We never have it get dissolved. We always have it so that the person is in full control. Now, yes, when a person's in full control, they have the ability to dissolve it or to get rid of it. So that part could have occurred the same if Elvis had given Lisa Marie full control at 25. She could have dissolved it. She could have gotten the money out. So I'm not suggesting that that would have stopped that problem. But by dissolving the trust at 25, that means that now that money is subject to Lisa Marie, to her, marriage, to her bad spending habits, to all of that stuff, and there is no protection at that point. So what I would say about Elvis is that the trust was the right move, but I think 25 and dissolving the trust was way too young, way too young. And I think we're going to learn from reading about Lisa Marie that essentially that is partly what happened. So Lisa Marie Presley, the daughter of Elvis, she had an estate plan in place, and I would call this a successful estate plan, okay? She established the Elvis Presley Trust, which left Graceland to her 3 daughters. She passed on January 12th of 23 at the age of 54. So that part is great, right? Lisa Marie knew that she wanted Graceland to continue on into the future. She left it to her 3 daughters. And, the trustees were her business manager and Priscilla. And then there was a fight later about her removing the business manager and Priscilla. But that stuff is really irrelevant. I think the part that I want to focus on is the fact that she did take steps to get Graceland protected. Now, the part that I want to remind all of us all is this. She was able to get Graceland protected because she didn't already have an issue. She wasn't already in the car accident. She wasn't already in the long-term care facility. She wasn't already having those kind of issues or in the middle of a divorce or any sort of creditor situation. When that trust dissolved when she was 25, if that picture didn't look the same, she may not have been able to then protect Graceland. Now, lucky for her, she was and she did protect Graceland and allows Graceland now to continue forward. She retained the management of it the same way moving forward. It's a 13.8 acre property in Memphis, which a lot of us know about. In 2020, Rolling Stones estimates that Graceland is worth between $400 and $600 million. Now, the part that I found intriguing as I was doing the research is that several articles mentioned that Lisa Marie lost much of her inheritance throughout her life, that the only real asset that she protected was Graceland. So the reason I bring that up is because I think the reason that happened is because the trust dissolved at 25. And now she was in full control, full access, full ability to lose, to spend, to lose. Luckily, she was able to get Graceland protected. So that's a great thing that will move forward now in the future for her 3 daughters who are left. She did lose a son a few years ago, but her 3 daughters will be protected. Graceland will be protected into the future. So the lesson here is trusts were used properly, but also, maybe the use was not used properly by having it dissolve at 25. I really don't think we should ever have trust dissolve. I think that we should allow a beneficiary to be in control. And there are ways to still do that, but provide the protection piece, but certainly not dissolve it. And if you're going to, I think 25 is way too young. I think that a lot of people these days are going through a lot in their 20s and 30s. I think that age should be much higher. Certainly something we can discuss on a one-on-one basis. So the lessons in this situation actually turned out to be pretty good, other than the fact that Lisa Marie lost a lot of her inheritance throughout her life. But the good news, we saved Graceland. We got it in a trust. We protected her 3 daughters. We avoided probate. We avoided the public process. And so overall, I would say good job. All right. Next on our celebrity lessons that we are learning through estate planning, we will talk about Philip Seymour Hoffman, an American actor. He's voted one of the 50 greatest actors of all time in 2022. And the lesson here is that he did not provide for after-born children. So after-born children are, if you have a will, in the will you provide for your children, and then you could add a clause that says, and any after-born children. That way, if you have any children in the future, it would provide for them. His estate was worth approximately $35 million. He had 3 children to longtime companion Marianne O'Donnell. The will only provided for this oldest child and did not provide for afterborn children. There was a New York statute that said afterborn children get the share equal to the child provided for. So in New York, and in most states, that would be the case. Now, and in this case, it worked out. Everything went to his girlfriend. But what if she had passed, right? What if the girlfriend had passed and it didn't go to her, and he didn't provide for afterborn children, and only one child would have gotten it? So I think the lesson here is, while again, it worked out, we don't want to count on luck. That is one of the phrases that I use all the time is luck is not a plan, right? So don't count on luck. Provide for the afterborn children. Provide for that. And, as I said, many states do have the afterborn child provision in their statutes. But of one of the major things that I have learned in over my 20-year career is that you don't want to rely on the government. You don't want to rely on statutes. You don't want to rely on the way they're written. They don't always do exactly what you would want, but you don't also want to rely on them not changing or not being revoked or just modified in a way that you weren't planning for. So document, 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 detail, detail, detail. So in this case, with Philip Seymour Hoffman, we learned that we want to provide for afterborn children. We want to be detailed in what we are doing in our estate planning. And in that case, it worked out for him and for his family. His girlfriend ended up getting it. And to my knowledge, from what I could read, did take care of the children. So I think it worked out. But again, that was a lesson in getting lucky. And that is not something that we want to count on when it's dealing with estate planning. We want to make sure that we're planning for it and providing for afterborn children. All right, our next celebrity is Jim Morrison, singer of The Doors, right? So he's a singer, songwriter. And I think the lesson here would probably be an oversimplistic will, which is a 2-page will, isn't enough. Now, for those of you who've been to my workshop, if you listen to these podcasts, you know that I tell the same story in every workshop, right? I talk about how we don't know who our heirs are. Heirs are not determined until death. I do the 2-finger test where I put my finger on the inside of my neck and I say, heirs are not determined until death, and therefore you can't have an oversimplistic 2-page will, because what if someone in your will or that you're providing for becomes disabled? They end up at the time of your death receiving public benefits, and because of the money that they inherit from you, they lose their government benefits. What if one of your children passes and that money now goes to a grandchild and they're under 18 or they're 18? We don't want someone getting a lump sum at age 18. We saw what happened with Lisa Marie Presley. We want that money to be held in a trust for them until they get older in life. So even for individuals that don't have large amounts of money, we don't want to rely on this oversimplistic will. Jim Morrison passed at the age of 27. He had modest assets at the time of his death, believe it or not, but he did own 25% of the Doors. So I have no doubt that that has turned into a nice lucrative amount for the estate and for the planning that he did. Morrison did have a will. In it, declared that he was not married and no children, and gave 100% to the girlfriend. I believe it was Pamela, if she survived him, and if not, to his siblings. Now, he was estranged from his parents, which is kind of important here because the parents filed suit arguing that he was not competent at the time that he did the will and that the common law marriage that he had with Pamela was illegitimate. The court disagreed. The court said that the marriage was legitimate, the common law marriage was legitimate, and also because of that, she would have inherited either way. So the parents didn't end up getting anything, but what happened was there was a large fight, held things out in a court litigation situation for a long time, and it could have been avoided. So the lesson here, I believe, is we don't want to rely on an oversimplistic will that doesn't provide. One of the comments that I hear all the time is, our base plans are 27 pages. Our trust plans can be upwards of 60 to 80 pages. And one thing I could tell you with 100% certainty is that I know that we have provided for just about every contingency that you can possibly think of. And one of the things I say all the time when I'm going through it is that we have provided a backup to the backup to the backup. We have a contingency for the contingency for the contingency. And the reason for that is because we don't know what the situation is going to look like when you pass, right? That 2-finger test tells us that we don't know who our heirs are going to be because our heirs are not determined until death. Therefore, we want to plan for all of the contingencies. And with Jim Morrison, the oversimplistic will it did not cover for everything that it needed to. And so that, I believe, would be a lesson that we learned from that one. One of my favorite track stars is Florence Griffith Joyner, FloJo as they called her. I believe one of the greatest female track stars of all time. By my personal opinion, I loved watching FloJo growing up. I love watching her run. Incredible. So I think that the lesson that we learned from this one is she kept the location of the will a secret, did not tell anyone where it was, which I get, right? I mean, I understand the logic behind that, but the problem is she passed in 98. No one knew where the will was. It took 4 years to close this estate because relatives were fighting, and they were all arguing that they knew what she wanted. She said this to me. She said that to me. I know that she had this. I know that she meant that. Look, one of the things that we do in our office is that we keep the originals in our office. We have literally built rooms in our basement that are secure, that are fire retardant, flood retardant. I mean, as much as you can possibly guarantee that something's going to be safe from flood and from water, we have done it. And it's under a security system, under cameras. I mean, we're talking, we've gone the whole 9 yards. And the reason we've done that is actually because of a case that I had where a grandson took care of a grandfather, right? Took care of the grandfather, did everything for the grandfather. And unfortunately, the will location was not known, although we knew where it was. It was in the house. But so did the former power of attorney, who was a daughter. And she was able to remove it, to shred it, to make sure that it didn't exist. And therefore, the grandson didn't get anything. And there was a huge fight over it. And what I learned was we keep the originals now, because that way I know where it is, the clients know where it is, and if there ever happened to be a flood or fire in our building, we could prove that it was in there, and then we could be able to probate with it. Because I could not unequivocally determine what happened to the will, even though we knew, we had neighbors who were witnesses, it just wasn't enough. The law says that it's possible that the testator destroyed it, and therefore, unless you can prove what happened to it, it's going to be as if the will did not exist, in which case the money did not go, in my case, to the grandson. So, Flojo, I think the lesson is, if you're going to do a will, I think make the location known, but I don't think it should be in the house like it was in the grandfather situation, where someone could go in and simply remove it and shred it. I think it should be somewhere in a professional, where a professional is keeping it. I don't recommend necessarily a safety deposit box, which I realize is not nearly as common as it used to be, but all kinds of reasons for that. But for me, I would keep it in a professional's office. That way we know where it is, and the family will know as well. So that was the lesson from Flojo. Michael Jackson, oh man, what a great singer, what a great performer. Holy cow. So I believe the lesson from this one is that he failed to fund a trust. He died in 2009. His estate was worth $600 million. So yeah, we're not going to learn a lesson from the amount of money, because that doesn't apply to most of us. He created a trust but never funded it. Now, this is where it can apply to anyone. Lots of people do trusts, right? We see them online. We see them on commercials all the time. We see estate planning attorneys talking about them. But if you're going to do a trust, if you're going to create a wagon, make sure you're putting the boxes in the wagon. Make sure you're funding the trust. Make sure that assets are titled in the name of the trust. And he didn't. He never put the boxes in. Family spent a ton of time fighting in probate court. Probate is a public process, subject to court approval, subject to judges. You know, trusts are absolutely valuable. They avoid probate. They keep stuff like that private. But you have to make sure that it's funded. You have to get the assets in it. So don't focus on the amount of money that he had. Focus on the simple lesson that even if we're just putting a house in, or we're just putting a bank account in for whatever purpose, whether it's avoiding probate, whether it's asset protection, you have to get it funded. That's the key to this estate plan. Or should I say, to this estate plan fail. All right. Next, Marlon Brando. It's funny. When I think of the name Marlon Brando, yes, of course, I think of The Godfather. I think of Vito Corleone. I think of Make Him an Offer He Can't Refuse. Yes, I do. But I also think of Marlon Brando, Jimmy Dean on the cover of a magazine. Dietrich and DiMaggio. Anyway, that's for another time. But Marlon Brando, I think the lesson here is supposedly he made oral promises. And so the problem is there's people who are arguing that he said this, he said that. He had an estate plan for his $100 million fortune when he died in 2004. His plan excluded oral promises that he made to long-term care housekeeper, Angela, and she argued that the house was a gift from Brando. She sought $627,000 plus the $2 million property for damages. Now, ultimately, the case settled for $125,000. You know, this is a tough one, right? Because I'm also almost trying to argue a negative here. Anyone can really make the arguments of oral arguments, and you know, it's kind of hard to prove something. But I think what I'm learning from this case as I read more about it was details. Providing in your documentation specifics as to what you're doing and not doing. The case settled for $125,000. When somebody's looking for $2,627,000, $125,000 is a nuisance settlement. Clearly, it was just to make it go away. I'm assuming there must have been a little bit there that they were worried about and just decided to give her something to make it go away. But I think the more detailed we are, the more specific we are, definitely will help in these types of cases. And it's certainly a valuable lesson in being careful that you don't say anything to anyone. I mean, whether that's true or not. And also that everything that you do should be in concert and following through with what the estate plan says. And I believe that that's the lesson in this case from Marlon Brando. All right. So next, James Gandolfini, the soprano actor. Oh, I love this guy. He's amazing. His problem was he never finished it. He had an estate worth $70 million when he died in 2013. He had a heart attack when he was in Rome. His will provided for his widow, daughter, and 2 sisters. His son from his first marriage was provided for in other ways, which is why he didn't provide for him in his estate plan. The problem was he didn't do tax planning, and they ended up paying federal state tax 55%. He did a plan very quickly before he went on vacation, and then he never finalized it. So I think the lesson here is, you know, a lot of people get estate plans done before they go on vacation, which is great. Get it done before you go on vacation. But if you haven't spent the time and done the proper plan, make sure that when you get home from vacation, that you update it, that you finalize it. Now, estate planning, from a tax perspective, as we sit here in 2024, isn't as important as it used to be, because currently you can pass with $13.61 million, and if you're married, another $13.61 million, for a total of, what is that, $27.22 million. Now, that isn't going to apply to most of us, but currently we are expecting in 2026 for it to come back to $5 million plus inflation, which we're guessing that will be around $7 million a person or $14 million for a married couple. So that may add some more people back into that issue. So my advice is, if you're anywhere near that type of wealth, even the $7 million wealth, you're going to want to talk to an estate planning attorney. But even if you're not near that kind of wealth, if you rush to get a plan done before vacation, please contact the estate planning attorney that you work with or who can assist you to make sure that what you did was good enough for the future and not just good enough for vacation. All right. Wow. This went really fast. We are definitely going to do a part 2 of our celebrity estate planning plans that were good and plans that failed. I'd like to thank you for joining me on this podcast of the Red Wagon Estate Planning and Elder Law Show. I'm Jeff Belomo, and I look forward to seeing you on the next podcast of the Red Wagon Estate Planning and Elder Law Show. Until next time, hey, we'll see you real soon.